been concluded as far as the hearing phase goes. As to the second part, the charges now for arbitrator service are between the arbitrator and the county. For 3 years, they were paid out of funds appropriated to the Judicial Council for that purpose. And in the overwhelming number of cases, they were $150. In about 2% of the cases, they were less than that, and in about 3% of the cases, if my memory is correct, an award in excess of $150 was made. Usually very slightly in excess of $150. I recall one case went on for 4 days. The arbitrator asked for $600. But I remember another case that went on for 4 days. The arbitrator didn't ask for it and received $150, which is, again, a sort of a pro bono thing. But typically, you're going to spend 2.5 or 3 hours arbitrating a case that would take 3 or 4 days to try. And I think that it's quite extraordinary that the additional fees will be applied for. But now, when it is the case, and when such an application is made, it's been between the arbitrator and the county of the place where the arbitration was conducted through, of course, the court system, which was engaged in the arbitration in the first instance.
So again, it's going to vary somewhat from county to county, and you better check your local rules.
That's right. There's a great many outstanding questions about the financing of arbitration that are vexing many of the courts, but I think they're probably outside of the scope of our hearing here, which our program here, which focuses on the practitioner rather than the court's immediate concerns. But to get back to the hearing, having terminated and the award being filed with the clerk gives a notice of entry, and you have 20 days to object and ask for a trial de novo. Bill's going to get into that now.
Well, we've been talking about the ultimate weapon or the ultimate solution to an award that you found as being unsatisfactory, and that's the request for trial de novo.
Well, Bill, let me interrupt. I want to cover one aspect before you get into that, and that is the setting aside the judgment on the award. We've covered earlier in our discussion some of the cases. I think the Wheeler case was one that touches on this area, how we can set aside this judgment on the award. Just be aware that in given cases, there are methods and cases that will touch on this. I think the other case that you had in mind, Bill, was the Amoroso?
Well, the Amoroso case really comes up with reference to the filing of a request for trial de novo, but there is another case which indicates the finality of the judgment and the effect of the judgment. And as Alex has mentioned, the award is filed, the time for requesting the trial de novo passes, and the judgment is then entered on the award. Now, that judgment is not like other judgments that you might have obtained after a trial, because that judgment is not subject to appeal. And the only way that you're going to attack it is under some pretty specific set of guidelines that are generally found in CCP 1286.2. There's a case that's in your materials called Lindholm versus Galvin that's worth taking a look at. And again, we have to stress that that is not a case that came up under judicial arbitration. It's a case that came up under another type of arbitration. But in that instance, the parties agreed that the judgment that would be entered on the arbitrator's award would be a final and appealable judgment. The arbitrator gave his award, the judgment was entered, one of the parties appealed, and the appellate court said, no, we don't hear appeals from these types of judgments. The only way you can give us jurisdiction is under the way that's provided in the CCP. And the fact that you've agreed that the judgment shall be appealable does not mean that we're going to hear an appeal of the judgment entered on the arbitrator's award. It's a fairly short opinion. You might take a look at it. I'd be guessing, and I'll hazard a guess, that one of the reasons they didn't want to take an appeal was that the arbitrator is not required to keep extensive records or documents that might have been introduced into evidence or what have you. It's a difficult case, but it points up, as do the rules under judicial arbitration, that once this judgment goes in, that's it. You're pretty well stuck with it, unless you can find a challenge under 1286.2. I think that was the issue that basically we were talking about, wasn't it, Norm?
That's right.
And I think the fact that no record is one of the most compelling reasons for the finality of the judgment. Reconstructing what had occurred for purposes of appeal or for setting the judgment aside would be very difficult, if not impossible in many cases.
Now, that takes us back then to don't let yourself get in the position where a judgment has been entered. The arbitrator's award is filed with the clerk of the court. When he files the award with the clerk, he's supposed to send a proof of service on the other party. I think for safety purposes, you better look and decide that the date of the filing of the arbitrator's award is the date of his proof of service. Or if he's actually got a date on the award form itself, use that date. Do not add things like 5 days for mailing or what have you, and there's a case on that point. You've got 20 days within which to file, not the mail, not the demand, but to file your request for trial de novo. And it's 20 days from the date of the date that the award was filed. There is a case in point specifically on this issue, and it's Amoroso versus the Superior Court of Contra Costa County, and that's cited in your materials also. That's a February 7th, 1979 decision, so it's prior to the new rules, but it was a case that came up under judicial arbitration under the old rules. And it's another one of those cases where if you get behind the case, you can find out some interesting things. It arose in the Bay Area. The plaintiff elected arbitration. There were two defendants. They went to an arbitration hearing. The arbitrator rendered his award. The plaintiff's attorney did nothing for a period of time. The 20 days went by. On the 21st or 22nd day, I'm not sure exactly when it was, but it certainly was not within the 20 days, he requested a trial de novo. The appellate court said, no. You had 20 days within which to request your trial de novo. The statute indicates that the time may not be extended, and you didn't file your request within the 20 days. You're stuck with the judgment that's been entered on the award. The case doesn't say so in the reported opinion, but in fact what happened there was that the plaintiff did get an award against the defendants. However, the plaintiff didn't think that the award was great enough. It might have been a different story had it been a defense verdict. I don't know. But in any event, the Amoroso case is the one case that we have presently on that point. Now, in a footnote in the Amoroso case, there is a very interesting point that is raised, and that is the question of whether or not CCP Section 473 can be used to get relief from the judgment that's been entered on the award. The footnote discusses this problem. I think that you will find that CCP 473 will not be usable against this type of a judgment. Again, it's the idea of finality. It's the idea if you don't move to exercise your right for a trial de novo within the 20-day time frame, you are stuck with that judgment unless it specifically falls under those grounds to challenge the judgment that you find in CCP 1286.2.
Bill, along the lines of all of these final judgments, 20-day period, we know that the arbitrator can award more than $15,000. You award, say, $20,000 or $25,000. What do you think would happen if an arbitrator did award $20,000 and the defendant